Welcome back to another episode of Sidebar Social. I'm Jennifer Grinke.
And I'm Dana Stewart. Here we are, first part of 2025. Do you subscribe to the whole I'm going to have a New Year's resolution thing?
Someone asked me this today, and I'm not really. I don't want to let myself down.
I'm kind of the same way. My daughter was like, what's your New Year's resolution? I'm like, I'll think of one next year. That's my resolution. I don't get into that.
Yeah, I don't really get into it either.
Yeah, so we don't have anything there, any resolutions. How about, how was the final part of your 2024? How did things go for you?
It was good. I went to Europe. I almost died.
Okay, tell me more.
But I lived, so that was good.
Wait, died in Europe or before?
No,
you talking about the before part?
Before.
Yeah, you got to get into that. So tell the people what happened.
Well, I went to go get my eyebrows waxed. I died looking pretty almost. And somehow I had like this crazy allergic reaction, and then they had to call 911, and I had to be rushed to the hospital.
In an ambulance?
In an ambulance.
Yeah. Was your face all swollen?
It wasn't swollen, but I had hives all over my body and this crazy itchy rash. And I think I was like the joke of the ER because everyone kept coming in and saying like, well, did you at least get the wax?
Yeah, we're like, look at my eyebrows.
Yeah,
they look good.
They look good.
Okay. So first time we've done this by Zoom. Our guest is appearing by Zoom.
Yes.
And it's the first time we're having a former judge on the podcast.
Yes, we are so excited.
Pretty excited to welcome former judge Suzanne Wooten, who is a friend of ours. And Suzanne, can you hear us okay?
I can. Thank you so much for inviting me.
We are really excited to have you on. You know, I'm going to jump right in. I don't know if you remember this, but when I was a baby attorney many, many years ago, I had a case in your court, and we had a gentleman who liked to use drugs. It was methamphetamine. And we got the drug test results back from the lab, and the lab told you, and you reported to us in court, that they said it was the highest level of methamphetamine use they had ever seen. And then you proceeded to ask the gentleman if he was getting high while he was taking the drug test. And he was denying that he ever had used it. But that was my very first time in your court. I'll never forget it.
Yeah, I tried not to be too sarcastic when I could help it because on the record, that doesn't come across when you read it later. But I do remember that because I've used that since then to say, oh my gosh, were you actually snorting the cocaine or taking the meth while you're urinating? So yeah, I do remember that.
Yes, yeah. Yeah, that was a very interesting first case in your court. But you were on the bench in Collin County, and you were a court of general jurisdiction, right? Can you let people know what that means?
Correct. So general jurisdiction, not all of our courts are, but Collin County now has some specialized courts, but back then they did not. So I heard everything from divorce to child protective services, contract disputes, commercial litigation, felonies, everything from third DWI up to capital murder.
It's a lot to cover.
Yeah, that's a lot.
It's a lot.
Yeah, I've always wondered, like, how do you even keep all that straight? I mean, so we stay in the lane of family law, and there's a lot to know in that one area. How do you keep track of all the different laws and rules and procedures?
Well, I'll tell you, when I very, very first took the bench, one of my first big cases, now I was an insurance defense lawyer in the past, so I had a civil background, but it had been a while. And I had this very complex commercial litigation. The one lawyer kept saying, oh, yeah, chapter whatever it was, chapter 24, I'll just say, chapter 24. And, I'm shaking my head, smiling. Yes, chapter 24, I think that applies. All the while thinking of what? Chapter 24, what? So thankfully, I figured it out. It was civil practice 42. It must have been 42. Civil practice and remedies code. But part of it is just smiling and going, I'm going to look that up. It's hard to keep track of everything, but you learn. You figure it out.
Yeah. How many times as a baby attorney have you thought, just nodding your head like, yeah, I got to go research that later?
I just always looked lost, like, hello.
Yeah, deer in headlights. Yeah.
That's her trick.
That's my trick.
So, one of the reasons why we wanted to have you on was to help shed some insight for the audience about some of your thoughts when you were a judge, just things that you've seen that potentially people did not do well, or things that maybe help you make an opinion when it comes to a family law case, when you're making a ruling on who has what possession or rights and duties, things like that. I know it's kind of a broad topic, but is there anything kind of top of mind that you could think of to help share with our audience of just tips or things to be aware of when they're in a family law court?
Certainly. The first thing that just off the top of my head that I think of is sometimes people come into court thinking the judge knows everything. They know all the details. We've got it. We don't. Obviously, they know what's presented, evidence, witnesses, testimony. And they also think the judge is magic. Like the court's going to be able to solve all these problems, where our courts tend to not micromanage stuff. They just really, really don't, because they can't. They don't have the time, the resources, nor the bandwidth when regarding, you're looking at the family code. They have to pretty much stay within the law. They take an oath. So one thing that parties forget is that the judge doesn't know everything. And more importantly, every single detail may not have the impact they think. And I know Dana and Jennifer, you probably had that feeling where clients are telling you, ask about the cat, and you're telling them, the cat, judge doesn't care about the cat.
Right.
Sometimes they forget that every little detail isn't part of the big picture the court needs to hear to make a decision.
Yeah, that's very true.
Yeah.
It's really annoying. We'll be at a hearing and you're trying to focus on, so let's say, for example, it's the opposing spouse who his attorney's asking questions to him, but then your client keeps tugging at your sleeve, trying to tell you, ask about the cat or whatever. It's difficult to keep track of that. When you're up there on the bench, when you were on the bench, are you jotting down notes as a hearing or a trial goes on?
So I actually, interestingly, all judges go to what we call new judge school or baby judge school. They don't teach you how to take notes. And so I went to one of our former judges, Judge Bob Dry, if you remember Judge Dry. I don't know if he was off the bench. And I asked Judge Dry, who I adored, what did you do? How did you take your notes? And he said, I don't. I doodle. And sure enough, he's drawing pictures. And for his brain, it worked really, really well.
Pictures of like the evidence? He's just drawing rainbows.
He draws a cat.
I mean, rainbows and kittens, I don't really totally remember, but doodling for sure. For me, I just learned to take notes where I actually split my page with a line and put whether it's plaintiff, defendant, respondent, petitioner, mother, father.
Right.
And I keep track of it that way throughout the whole proceeding. That way I can go back and put responses on one side to something else with an arrow. I take copious notes. I always did.
How did you know when to interject and ask your own questions versus letting the lawyers ask questions to the witness? That's kind of always a big one. I'm like, I've had some trials where the judge tries the whole case against me, and then I've had some where they don't ask a question at all.
A good question. So maybe it's old school. I came from the school of the judge is not there to ask the questions. The lawyers need to put on their own cases and ask the right questions. Occasionally at the end, maybe you're in a temporary hearing or a final hearing, and there was just a detail, not substantive though, because I can tell you if your whole case is about child support modification, no one asks about income, I'm not going to interject that because that's kind of your job as the attorney.
Yeah.
But I've certainly had ones where at the end I would ask, does anyone object to me asking a question of this witness? Which, by the way, you can say yes. You could say, yes, I object, or that I wouldn't ask. Usually it was a no, go ahead. But honestly, I would keep track of questions if I had them for at the end to say, does anyone object? But I tried to be very, very careful not to step on the role of the attorneys as advocates because I was the trier of the facts presented to me if they presented them.
I don't think I've ever had a judge ask me if I have an objection to them taking over a
I learned something
hearing.
new right now.
Yeah, I didn't know that was an option, Judge.
It is. Now, they may not like it, but it's true. You can say, yes, I do object. I mean, if anything, you're preserving the record, right? Because if your other side did not meet their burden and now the judge is asking questions to help them meet their burden, whether intentionally or unintentionally, well, great. Now you want to protect the record for appeal at the very least.
Right. Mm-hmm. Well, I've got a question for you about a motion to confer, if you don't mind getting into that a little bit. So for the audience at home in the state of Texas, if you have a child that's 12 or older, you can ask the judge to interview that child. And it is mandatory, I mean, unless there's a jury trial, but we'll just assume no jury trial. We don't usually have many of those. But I'm curious what goes on behind the doors or in your chambers. So we ask that you interview our client's child. We set a time for that child to come up to court and speak with you. Can you talk a little bit about whether it's the way you would structure those or how you go about that conversation and what you're looking for in that conversation?
Certainly. And I can tell you, I mean, I don't know how every judge does it, obviously. I can tell you what I did. Typically, I would do it after a hearing, whether it's temporary orders or final, because I need to know what's really being disputed, right? Because just having some blanket conversation with a 12-year-old may not be very productive, right? But I also typically would tell the lawyers, if you all want to give me some suggested questions, I may or may not use them. And the lawyers have to share them with each other, too.
Okay.
So granted, they may be objectionable. I may not use them. But typically, what I always did was have my court reporter in with me, not necessarily making a record. No one ever asked me, by the way, for a record. You can't ask for it.
Right.
I think personally, I think it's a bad idea because we don't want the parents to use that record at some point by showing the kid or referencing it. And I wanted the children to speak freely and be able to honestly tell me. But I can tell you the very first question I asked every single child, besides, how are you? Come in, was, so why did mom say you were here? Or why did dad say you were here? Because I was always curious if they would say, mom told me just to tell the truth and, say how I feel. That's usually the right answer. Or, well, my dad said, you need to know that my mother is abusive and she's a, gaslighting narcissist. I mean, words that kids never, ever say.
Yeah, that's a big red flag then.
A little bit, yeah.
And would you typically admonish the parents before you'd interview a kid to tell them, do not speak to your child or children about this conversation I'm going to have with them?
Typically, the lawyers took care of that. If there was a case, I can think of one, I won't say names, where I did do that because I thought, okay, you guys quit, because they were playing the children against each other. And I did say, I'm talking to your kids, and neither one of you are not only not speaking, but do you have a volunteer, someone else who will drive them here? Because I wanted to make sure nobody was in their ear in the car coming to the courthouse for the conference either.
Yeah.
Judge, now you're full-time mediating. So how has the transition been for you from going from the bench to a full-time mediator?
So I'll tell you, it's interesting because for one thing, I don't get to decide anything, right, as a mediator, whereas on the bench I could. So I have to always remind myself to, not always, some cases are easier than others, stay in my lane, right? Whereas when you're a judge, you can just sit there and think, yeah, you're going to get it after I'm done with this. And when you're a mediator, you have to think, okay, how do I gently and lovingly express to the other side that their outrageous and ridiculous request is not going to be accepted? So I had to really work on adjusting my frame of mind as well after being able to make decisions to how do you persuade and help people get to a resolution instead of dictating the resolution.
Yeah, and I feel like the fact that you had that experience on the bench makes you such a better mediator because I can see that coming through when you're mediating our cases.
Thank you. Very, very kind.
Yeah, and one thing I like about you, too, is I know that you've still got a close relationship with many of the judges here. And so I know there's been many times in mediations where you have said, oh, yeah, it's my understanding, Judge so-and-so, their tendency may be, to lean this particular way on a certain issue. And you bring that insight that I think a lot of mediators don't have because they don't have those connections like you do due to your time on the bench.
Yeah, I do. And thankfully, the majority of the judges I deal with anyway are very open to answering very broad, general questions because everything, as you know, is prefaced with, well, depending on the facts, depending on the case. But it's very helpful for me because if I know a tendency, like you said, about whether a court grants modifications of geographic restrictions, lifting them, for example, it can help me say, look, my understanding is their position is generally like this. And it kind of helps give a little bit of insight into what could happen. But of course, I don't know what will absolutely happen. But I think that contact is helpful because the judges are very, very willing to give very general answers to questions because they would rather have things resolved than them trying to.
Right.
They really would like their dockets not so packed.
Follow us and join the conversation on Instagram and YouTube at Sidebar Social.
To learn more about Grinke Stewart Family Law, visit GrinkeStewartLaw.com.
Okay, Judge, I want to kind of expand upon, we're talking about those connections you have from your time on the bench with the current judges that are on the bench. Have you noticed a trend in your mediations or just in general that some of the courts are moving towards 50-50 as a starting point for possession schedules and moving away from the more old school standard possession way of doing things?
I have. I've actually seen judges who initially were we're going by the code, period, no matter what. It has very kind of consistently been moving toward a 50-50 schedule. Personally, I think part of that is a reflection on what our legislature has been doing, which is moving it more to a 50-50 schedule, and the realization that both parents should be active as much as possible in a child or children's lives. But I have definitely seen courts way more willing to do a 50-50 schedule, but you still have those same factors. Proximity, do they live close enough? Can they get kids to school on time? I mean, there's so many advantages to that equal schedule for the kids psychologically too, and I am not a mental health expert. But I have heard and seen that those schedules tend to make the child or the children feel more acceptable, that they have two homes instead of what used to be the theory of home base. I always hated that expression.
Yeah.
Because one parent is typically not superior over the other in the eyes of the child, for sure.
Right. Except for in my situation, but
Except for you. Yeah, I mean,
of
Dana,
course.
you're awesome. We
Yeah,
knew that.
of
We knew
course.
that.
Yeah.
Yeah.
So we want to get into you want to talk a little bit about her thoughts on, we're just kind of curious from your perspective, insight in preparing for a mediation, like what we could do with our clients or what people can do to help set the case up for success when it's in your hands.
Mm-hmm. Yeah. Do you have any tips we could give the clients?
Absolutely. Number one is actually having a conversation with your client in advance. And I know you guys do. You all are always very prepared, and I appreciate that a million times. Making sure that the clients are aware, not only that the mediator doesn't decide, but that it is a process for both rooms. I have seen kind of a trend recently where one room wants to dominate the time. Now, I don't know if that's a power struggle or if it's part of control. We see a lot of that. But if I'm spending an hour and a half in one room, then I have to go to the other room an hour and a half. Remember, we are on a clock, right?
Yeah.
So we have to be kind of mindful. But for me as the mediator, the room that's waiting sometimes is getting anxious, upset. Often they start deciding there's some evil or ulterior motive going on in the other room.
Oh, yeah.
So if you make sure your clients are aware there is downtime, but we also need to be really focused and be prepared to kind of cut to the chase to get both rooms having an opportunity to have a say in the outcome.
Yeah, and let's remind people that mediation's a confidential process, right? So what does that mean exactly?
Well, exactly. So I like to describe it as this big bubble, right? We have this big bubble of confidentiality that we're all inside of. So anything offers, counteroffers, all of that stuff has to stay there, which part of it is there's no recording. Jennifer knows what I'm talking about.
Yeah.
It wasn't her.
Yes.
No recording of mediation sessions. No. Oh, somebody asked me the other day, can AI take the notes for me? And I said no. And part of the reason is, although lawyers should be able to take their own notes, but you don't want clients or parties to go back to the other side at some point and say, see what the mediator said? And the mediator may not have meant that. You could take things out of context.
Right.
I don't like recordings for sure, because of confidentiality, but also because of weaponizing it down the road. Do not ask how the sausage is made, is what I like to say, right?
Yeah. Part of the mediation maybe is like the mystery, the magic that goes on with
Yeah.
the mediator.
You're like the Wizard of Oz back there behind your curtain.
Yeah.
Right.
Yeah.
Don't look behind the curtain. That's correct.
Yeah. And so how do you go about, one of probably my favorite expressions I've heard from you before, and is that when we have a case with a difficult party or difficult parties, I think you excel in navigating those waters. And your expression is, I pet crazy, And so I'm curious, like, how you go about when you are dealing with somebody that's very difficult to get through. How do you remain calm and patient and still empathetic, but still drive the mediation forward?
Good question. I don't know. I have 3 children. I don't know how I did it. For some reason, I do have some weird knack of, and I know petting crazy is probably not a politically accurate, correct thing to say, but talking people off of ledges. I think part of it is I really try to connect with each party on just a human level, whether it's somebody's a car person, and Dana knows I'm a car guy, or if it's, I may or may not curse in 21 languages, maybe something about their cultural history or where they're from. I'm from Chicago, lots of different things. I try to connect and also help them understand I've been there. I have an ex-husband, and although our divorce was very amicable, we do have a child who's Dana's age, probably, unfortunately. But having that connection also helps me kind of keep people a little calm, because I do appreciate that it is a high stress situation, probably more stress than they're used to.
Yeah.
And people, hate each other sometimes. And I try to be like, okay, everybody deep breath. I can't tell you what magic potion I use. I don't, to keep calm, but I'm able to, because I know how important it is to have that control in the outcome and the resolution from their perspectives instead of a stranger in a black dress.
To connect with today's guest, Judge Suzanne Wooten, check out her company at NorthTexasLitigationSolutions.com. And they're also on Facebook.
Okay, so you've been a judge and you've been a mediator and you've also been in private practice. What do you think is a more effective way to resolve a family law issue, whether it's in the courtroom or through mediation?
Well, I can tell you I'm a little biased. I do believe it's mediation. If you can, obviously, not everything can be settled if people have unrealistic expectations or the principle of the matter, right? When it's the principle, no, it's never the principle. It shouldn't be. But I think the fact that people have that ability to create solutions, whether it's really their idea or maybe the mediator makes them think it's their idea. That's some of that sausage creation, don't ask.
Yeah.
I think people tend to be more satisfied and less likely to come back to court later, like for a modification, if they were part of the solution.
Right.
Generally.
Yeah.
Some people just can't be happy. I mean, it's true. Some people just hate each other.
Yeah.
That's true.
So let's talk a little bit about your current role, the mediation role, your business, North Texas Litigation Solutions. So you have a whole team that is there. You want to talk a little bit about your team?
Sure. Thank you. I do. I am still an attorney. I practice this much law. I have a very small client base because I do mediations, arbitrations, and some special master stuff too, discovery master, etc. I have grown the team. So we now have myself, Judge Rhonda Hunter, who's a former family court district judge in Dallas. Judge Don Turner, who was a family court associate judge in Dallas for like 12 years, I believe.
Yeah.
And prior to that was with the Attorney General's office. So he's got a lot of backdoor or, behind the scenes insight on how the AG works, which is really helpful in some cases for sure. I also have Judge Andy Chatham, who's a former district judge out of Dallas. We have Keith Becker, who is a board certified family law attorney who offices mostly in Prosper. Michael Poole, board certified family law attorney who offices here in my McKinney space. At John Stewart, who is a 50-plus year board certified civil mediator who does probate and civil, nicest man, incredibly effective, kind of a older but really, really smart. And then I also have Dale Rose, who's a local guy who's been around forever, who is also a civil litigator and one of our senior mediators on civil cases. So we have a team that kind of offers family, civil, commercial. I do federal appointments. We try to really encompass every need you guys may have for a lawsuit to avoid the courthouse if we can.
And let's not forget the most important person on your team. It's Jackie, right?
Oh, I love Jackie.
Miss Jackie, yes. Shh, don't tell her because we just had Christmas and she got a bonus. Jackie has been with me for a number of years. She is the keeper of all things calendar. She manages everybody's calendar. And she, as Dana and Jennifer know, is probably one of the nicest people you'll ever meet too.
So nice.
Which helps because she has to pet people sometimes. appropriately.
Yes. Well,
after asking permission.
Yeah. Tell Jackie that we said hello.
I will. Because no offense, Jennifer, but Jackie does have a little bit of a crush on Dana.
He brags about it.
So
awesome.
I
brag about it. That's right. Yeah.
He does.
Yes. She's got a big picture of him on her. It's next to her Robbie Benson poster. Anybody? Do you guys even know?
I know who Robbie is. See, I have my fans too, Jen. Okay.
See, that's right.
Yeah. Jen has.
He just needs to autograph.
I have fans. Jen has stalkers. There's a difference.
Mm-hmm.
There is a difference. Well, but that's why you need Dana to protect you, since he's
Mr.
Mr. Self-Defense.
I got her back. So before we move into kind of final part, closing arguments, anything else you can think of, Judge? Any nuggets of wisdom that you could think of? I'm putting you on the spot, but just for the audience, whether it's mediation, courtroom, revolving around any of those topics.
Well, I mean, one thing I kind of was just thinking that since you mentioned this at the top of the show that we are virtual, that because I'm not where you are located physically, I have to say that just generally speaking, this format of being able to do mediations by Zoom has really increased the settlement rates by about 5%. I have now mediated about 1,250 Zoom mediations alone.
Wow.
And I think there's some people who are very resistant still, but honestly, the comfort level of parties not physically being in the same location and the flexibility that Jen could be in the Palace of Versailles if she needed to be.
She's been there.
People I know, I heard. I saw the pictures.
Oh, good. It was really fun.
I saw the Interpol pictures. I'm kidding. Yeah. But I've had people in Taiwan, in Brazil, Hawaii, you name it. I think people have tried to say we need to move back to completely in person. I just don't think that's really true. I think this is going to continue to live on. And I definitely encourage lawyers to keep doing it this way because it is a service to their clients to add to, if nothing else, the comfort level emotionally for them.
On the way here, Dana's telling me that opposing counsel won't mediate Thursday via Zoom.
Yeah.
Because his clients clients get distracted by snacks when they're on Zoom.
Yeah, I have an attorney who refuses. We're set to mediate in person on Thursday, and the attorney's like, it's going to be bad weather. And I'm like, let's do Zoom. And he goes, no, people eat snacks on Zoom, and then they get distracted. I'm like, what the hell are you talking about? I'm like, this guy doesn't know me, Judge, with my lunchbox of snacks I'm going to bring, whether we're in person or on Zoom.
It makes no difference. That's right.
Yeah. Anyway. Yeah.
That's so weird. Thinking like corn nuts, like what snacks?
I don't know. What are the distracting snacks?
These are people with goldfish memories that they're distracted. Look, a shiny corn nut.
Right.
Okay, Judge, so the last part we do something called closing arguments. So Dana and I are going to give our best argument over the same topic, and today it's geographic restriction. So my client wants to move away and take the kids with her, and Dana's client wants to stay here in the DFW area and keep the kids here and prohibit her from moving. So usually I let Dana go first so that I can hear what he says and say something better. So go ahead.
Strategy. That's right.
Yeah, that's why she's pretty much undefeated, I think, except for in one
I'm
of
going to
these.
lose today because
Yeah,
you said that.
Right. So, all right, Your Honor. First thing I'd point to is that the parties agreed just 2 years ago that the geographical restriction would remain in the DFW area. My client gave up certain things in the divorce process to ensure that the kids would remain here, and now mom wants to move away. And I understand she's saying that she thinks it's going to be better for the children, but they have relationships here in the area. They've gone to school here their entire life. And if you look at the long list of factors from the case law, the Lynn's case, that you're supposed to cite to when you're deciding or when you're looking at whether to make this decision, I think in the long run, it's going to be more detrimental to the kids who are very bonded with their father. My client, he's heavily involved. He's always been in their life, and to now move them out of state, it will severely impede that relationship, and it's just not going to be the same. And for lack of a better way to say it, it's really not that fair to my client who has upheld everything he's agreed to in their order from 2 years ago.
Well, what
Ms.
Dana...
Grinke?
Yes, thank you, Your Honor. What Dana has failed to mention is that his client...
It's Mr. Stewart, thank you.
What
Mr. Stewart,
Mrs.
yes.
Stewart. He gets called a girl a lot.
That's
What
true.
Mrs. Stewart has failed to mention is that his client isn't that involved. He's only exercised about 25% of his time. And my client has the opportunity of a lifetime to move to LA to star in a film and various other films. And this is a great opportunity for her, and it's a great opportunity for the children. They're going to be in the top of the line schools. They're going to be able to maybe also have a role in this film. This is just sort of a once in a lifetime opportunity. They also have family in California, so they're going to be around their cousins and their grandparents and other people that they don't get to have as much opportunity to see. Dad has a flexible schedule. He has a flexible work schedule, so he has the opportunity to fly to California. In fact, he works remote. He could also move to California. So I just think this is something that this family can't pass up, and that this is what's best for the kids, and this is just a once-in-a-lifetime opportunity for these kids and this family to really excel.
Wait, you're talking about cousins, grandparents. Do these grandparents...
Mr. Stewart, do not address opposing counsel directly.
Okay, yes. I'm just curious, are you talking about your own family? Is this what we're doing here?
Oh, this is personal.
Yeah, I think it's
Oh.
personal, Judge. I'll rest. It's okay.
From my perspective, you need me to say which argument was the best. Is that
Yeah, whatever comes
Who
to
won?
mind. Yeah.
Well, I've heard that kind of an argument before, and I would probably deny the request because nobody told me Dad could afford to travel back and forth for visitation, because that's a problem. And unfortunately, and Jennifer already knows this, so she kind of had the uphill battle in the argument.
Yeah.
It's our public policy to keep this in place. You can be a crappy parent. Maybe don't air that part, but you can't be abusive and neglectful. So he's going to probably keep having an opportunity to stay put unless he really, truly, completely drops off the planet. I didn't really hear that. Sorry. We're reactive, not proactive.
Exactly.
Maybe we could get him a role in the movie.
Yeah, maybe so.
Yeah, that would be
Okay.
better.
All
Yes,
right, then I'll
make him a
move.
star.
That's right.
Ta-da.
So I think that does bring up a good point. I've had, and I know you have too, Jen, like we've had several cases where we were either fighting for or against the lifting of a geographical restriction. From your perspective, Judge, is it pretty rare that you would essentially grant that request to lift the restriction? I mean, I feel like it's a hard thing to do, but curious what you think.
Yeah, honestly, it is a hard thing because not just public policy, but based on the facts, if one parent is able to maybe not do all the soccer stuff, but go to school for lunches and do other things and be active in the children's lives, barring some, as we mentioned, really bad facts like they're meth addicts or in jail for DWI constantly, they're going to have an opportunity to hopefully not mess up their children worse than they may be. But I do think geographic restrictions, generally speaking, are hard to move, especially if, like Dana mentioned at the beginning of his argument, they were agreed upon to begin with. Mm-hmm. Then obviously people were anticipating staying put for the foreseeable future. And in that regard, it's kind of hard to undo agreements. That makes that, to me, that's another layer of difficulty.
Right. That's why I said it. Thanks for the win, Judge. So we want to thank you for taking time out of your busy day to come on to our podcast. It was really great being able to speak with you and get some insight from your mind as a judge and a mediator. And
you're welcome. Thank you for having me.
Is your mediation calendar still booked through like months and months in advance?
I do tend to book out. However, that's the other wonderful beauty about Miss Jackie is that she keeps the calendar and a running list of special people that which really just call, when I have an opening, she'll start running down the list. Hey, this Friday opened up or that Tuesday. But we have an interactive calendar that's live. You can always check. It can change daily. So I stay busy. Thank you.
Yes.
But I do need a vacation. Next time Jennifer goes to France, she needs to remember other people curse in French, not just her.
Yeah.
Yeah, she's a world traveler. So, well, thank you so much for coming on. Glad to see your practice is still booming and wish you a very successful new year.
Thank you. You too. I appreciate it.
Thank you.
All right, we'll see everybody next time on Sidebar Social.
Bye.